Okay, so folks, this is entirely about the law that was passed last week, and so we're going to be talking about meetings. We're going to be talking about voting and what this new language is and how it affects everybody. I will tell you, just as a precursor, when this came out, I started reading it. I thought, yeah, this is going to be, I can summarize this in 5 or 6 slides. It'd take me 20 minutes. It's extensive. And because it's extensive, I don't know if we're going to answer all your questions today. I'm going to try and jump and get through all of the bill, all of the new law, what it means, and you know, how it applies to you. And then I'm going to give you a recommendation at the end, so for your advice. So I'm going to jump right in. The new legislation, if any of you have ever seen this quote, you never want to see things being made, the sausage and legislation specifically. And for some reason, Otto von Bismarck said that, the German chancellor from World War I. I don't know why. This bill is called, that's now law, is the Bill to Modernize Remote Business Access. It's signed last week. I will tell you that it went through 5 renditions. The initial drafts changed the Planned Community Act and Condominium Acts in 2 specific sections. Those were removed. So there's no changes to the Planned Community Act, no changes to the Condominium Act. The changes are solely to the Nonprofit Corporation Act. They are also for the For-Profit Corporation Act. They're between the 2 acts, there are approximately 20 changes. That's why this is an extensive bill that's now law. I'm going to try not to overcomplicate this. There are some of my colleagues who do that. I think when it comes to you guys managing your boards, the simpler the better, if possible. And so that's how that's how I'm going to approach this. The first thing we need to address is, what are we talking about? The bill, the new law has changed how meetings can be conducted, but we need to determine first, what are we talking about? A meeting is the following: a meeting of the members where you're conducting business, voting on something. Okay, that's a key distinction, and you have to keep in mind when we're reviewing all this. Action is taken by a vote. Minutes reflect that action. We're talking about member meetings. We're not talking about board meetings. There's one change to the board meeting statute, but it's really not. It does not really apply here. What we're talking about today. So when we're talking about meetings, we're talking about votes being conducted, business being conducted, as opposed to a gathering, assembly, a party, a session where you're not conducting a vote. You're not taking any action. Okay. Keep in mind the changes to this law deal only with meetings. And the distinction there, of course, is when you have a gathering, it's for informational purposes only. You're not going to conduct business. You don't have to take minutes. So please keep that distinction in mind. Over the last year and a half, just to give you some perspective, almost every association who has informed me about how their annual meeting went did their annual meeting last year with an a written ballot where people mailed in their votes, and then they had their informational, they called it a meeting, but it was a gathering where they discussed everything. So please keep that distinction in mind. So what's changed? Just to set up how this is going to go. I'm going to go through the major things that changed. Then I'm going to tell you a summary of how it applies. Okay, so what you're going to see first, for example, one of the biggest ones is this section, 55A1-7. And it provides that unless the bylaws of your association, it's a nonprofit corporation, unless the bylaws or the articles limit the association's power in some fashion, associations and all nonprofit corporations may conduct business by electronic means. Now, it uses the words electronic means. It doesn't tell you what that means. It just means electronic. We're left to determine a little bit what that means, and we'll get into that a little later. The second part of that statute, and this is the big one. You've heard the term opt-in in the past for members wanting to communicate via email. It's the same thing here. Members must opt in or agree to conduct business and communicate via electronic means by providing an email address. The association is required to tell members how they can opt in. So the first action item at some point coming up on your annual meetings, because I know this is an annual meeting session, if there is a desire for the association to hold its annual meeting virtually, and you want us to communicate with members electronically via email, the association is to inform members how that is to happen. You're to contact members and say something like, if you wish to receive notices and communications via email, please provide it. That email that you provide is designated to be the one that the association will use to communicate. Now, let me just stop right here just for 1 second. The General Assembly has given us a new law, but they are not telling us how it works. So that's what we're talking about here. So keep in mind the language that you can put that you send out to members that indicates you can designate your email. There is no suggested language in the statute. Keep it simple. You want to communicate and conduct business in this fashion, you must provide us an email address, and that's the one we're going to use. Keep it that simple. The second, and I'm going to move quick, and so if you have questions, we can deal with them. Let me get through the first part of this, and maybe we can stop and take any that are out there. The second major one is 55A 701 and 02. Annual, regular, and special meetings may be held in person or by means of remote communication. The words remote communication are in the law. It doesn't tell you what that means. Does that mean via any specific platform, Zoom, meetings? No, it just means remote communication. It means virtually. The next change, 55A 709 A and B. And this is the first time, and in reading this and getting ready for this, that I went, huh? And you're going to see why in a minute. Members may participate, this is 55A 709 A and B. Okay, members may participate by means of remote communication if allowed by the board. Now, in looking at it in a vacuum, I read that initially to mean that if the board calls an annual meeting, the members may choose to attend in person or by remote communication. That it would be a choice by the members, because it says members may participate. It's their choice. If they, and the rest of the statute goes on to provide that the board must verify that each person who is participating virtually is a member. We're going to talk about what steps you can take to make that happen a little later. Remote members must be provided an opportunity, reasonable opportunity to participate and vote. So if you have a virtual attendance, you must provide the opportunity to participate and vote. What does that look like? What does that mean? We're going to talk about that at the end, but I'll tell you just as a preview, if the person who is attending virtually is having connection problems, that's not the association's problem. You'll provide means by which they can participate. If they can't or they choose not to, that's on them. That's not on the association. But it begs the question, the way that was worded. What about a mixed or hybrid meeting where you have an in-person and virtually? Is that an option? I don't understand based upon that. And when I read those two sections of that statute, I started questioning exactly what do these meetings look like? Are you allowed to mix them? You'll see a little later that the answer to that is, in my opinion, is no. Continuing. We're going to, if you recall the last slide, it was 55A 709 A and B. We're going to go to C and D now. Unless prohibited by the articles and the bylaws, the board in its sole discretion may designate that a meeting be held solely by remote communication. Solely means must, shall, only. I read that to mean that the question that I asked in the last slide about a mixed or hybrid meeting, the answer to that is no. Because the board makes the decision to hold a meeting either in person or virtually. It must choose one or the other. It cannot mix them. The second part, which is subsection D, is any notice of a remote meeting must include instruction on how to join. That just kind of makes sense. I will also tell you, I didn't put the exact language in that little blurb, but it again uses the word solely by remote communication. So I read those together and come to the conclusion that it's, as I like to say, inartfully worded about member participation, the prior slide, but in the end, it is the board's decision on whether the meeting will be solely virtual or solely in person, one or the other. Don't mix them. That's the mandate. Another big change, proxies. If a member has opted in, if you go back 2 slides ago, 55A-1-70, if a member has opted in to conduct business electronically or communicate electronically, then a member can appoint a proxy via electronic record. Now, who is he supposed to send that record to? The statute doesn't say, but most likely I would tell you that's going to be the secretary of the association, a board member, or even the manager. That proxy is valid if it bears the electronic signature of the owner, which is not new, that was always available, or it's sent from the designated email address that owners provided to the association when they opted in. So my email address is chris@McIntoshlawfirm.com. And that is the one I have designated to the association as the one to communicate with me. If I send an email appointing Donna as my proxy for this meeting from that email address, it's a valid proxy.
This is a new law. It's not real money.
Can you mute, please?
Brittany, could you mute unless you do for the moment?
Oh no, I'm so sorry.
That's okay. So keep in mind, members can change their email address and forget to tell the association. So that's the first thing we have to figure out. What happens if the email address changes? The association, is it the association's responsibility to go every year and say, has your email address changed? Or is it on the members to designate and update? The way the language is written in the statute, it is my opinion that is on the members to designate what email address is to be used. If they change it, it is on the member to tell the association, my new email address for electronic communications is whatever.
And Chris, for clarification, it's one email address per homeowner, correct?
Well, it doesn't say that in the statute, and that's important. You'll see I get into that a little later.
Okay.
When we deal with, if we do have a virtual meeting and you have a husband and wife or two or co-owners in some fashion getting on separate locations, who votes? Good question. I'm going to try and deal with that a little later. Keep in mind too, and this is always the deal with proxies. If the member who provided the proxy attends the meeting, then the proxy is revoked. So if I send in my email proxy appointing Donna and then I attend a virtual meeting, Donna doesn't get to vote for me. Likewise, I can email a revocation or some other way deliver a writing revoking that proxy to the association, and that revokes it effectively. Okay, notices. We all have to make sure that we notice our meetings correctly. The one first change here is 55A1-41. And this language I have toned down because that was a long paragraph. Basically is this: an electronic record, in other words, an electronic notice sent via electronic member means two members who have designated or opted in is effective. That means for members who have opted in to receive electronic communications, you may now send them notice of an annual, special, or regular meeting via email, and upon sending that, they are deemed to have received that notice. Big change, huge change. This must be read in accordance with 55A7-05, which is the other portion of the notice sections in the Nonprofit Corporation. And you will all remember, hopefully, that there is a notice provision in the Planned Community and Condominium Acts, which is a little different than this one. Keep in mind that the most specific language controls, meaning the Planned Community Act and the Condominium Act language will apply where it conflicts, if it conflicts with the Nonprofit Corporation Act. If it doesn't conflict and they can be read in conjunction, then that's what you do. And you'll see what I mean in a minute. 55A 7-05 says notice is fair and reasonable if the association gives notice of the place, if any, time and date of the meeting, not less than 10, no more than 30 days from the meeting. Now, if you recall, the Planned Community Act is 10 to 60, so it's the Condominium Act. So that's a little different. But I would tell you that my interpretation, statutory interpretation coming through law school tells you that for planned communities and condos, it's a 10 to 60 day requirement because that's what's in the specific section. But the remaining portions of the notice requirements from the Nonprofit Act would still apply. If it's a remote meeting, okay, then notices to include the information required by 55A-7-09. And that was a couple of slides ago, where members are going to be required to be allowed to participate and hear what's going on. Time, place, location, how to log in, how to participate. That's going to be required in the notice if you're doing a virtual meeting. This is this language actually, Donna, my paralegal Kate read this earlier and had to question me on it. So I want to make sure we all understand this. If that section also provides that if a meeting is continued, if it's continued by remote communication, meaning you have a virtual meeting and you have to stop it for some reason and move it to another date, the announcement that it's being moved shall include a description of the means of remote communication where the meeting will be recalled. You can't just say, we're going to reschedule this meeting for 2 weeks, goodbye. You need to say, or you need to announce, we're going to have this meeting again, reschedule this meeting for 2 weeks. We're going to use the following remote communication. It needs to be clear. Changes to, okay, so what we have just addressed so far is the ability of the association to hold meetings via virtual meeting, how members are required, how members can participate, and the ability for, we've addressed proxies and we've addressed notices. Now, over the last year, as I've said, most associations have conducted their annual meetings via written ballot. And if you recall that procedure, you mail out the ballots, you give them an option vote yes or no, you put a date by to return by in order for the vote to be counted, and you give them a time frame to do it. However, the votes came back, whether it was email, mail, fax, hand delivery, those votes were counted. If you had a quorum return, then you could count your votes and either the action passed or failed. There's really no difference in that procedure, except now any action that can be taken at a meeting may be taken by written ballot, what we just discussed, or electronic voting. That's the big change. The platforms, for example, like SurveyMonkey, or a virtual platform where you can log in with a specific login information and vote on an item that is before the association, can now be used. Before, there was a question about that. I know one management company that believes they could have used them the whole time, but there was no real statutory mandated or allowance for that. Now there is. The meeting, meaning the business, occurs via written ballot or electronic voting. We'll talk about that a little bit more in a second. But the ballot, if you mail out a ballot or email out a ballot, it must contain a description of the vote, the return by date, and the opportunity to vote. And it can be in electronic form with proper notice. So when you send out your notice of the meeting, you can include information that says you may log in on this website using this specific login and vote on the issue. Or you could, if you email the notice out or mail the notice out, attach the email ballot. I think this change is probably one of the best in the law because it frees up the ability to use this process to vote on items before the assembly and before the association. If you recall, written ballots must be delivered to every member. Same deal, no change there. The distinction here that has changed is that there must contain a request information on the ballot to sufficient to identify who's voting, the member or the member's proxy. So when you send out a notice, for example, to use SurveyMonkey to vote, I'm just going to use that platform as an example. There has to be some sort of identification or ability to identify who's voting. Now, if an owner has opted in, sent you an email address and said, this is how I want my notices and how I want to communicate and how I want to conduct business. If you send, in my opinion, this is my opinion, if you send a login information to a SurveyMonkey platform that requires that person to enter their email address and perhaps even a password that they make up to vote on an item, I would submit that that's sufficient information to be able to ID the person voting. The issue that could come into play is you deal with proxies, and proxies have to throw a wrench into this that I'm not sure the legislator thought about. Written ballots, again, if you email a ballot out and it comes back from that email address, I submit that it's proper, but that's enough. They may be submitted by any reasonable means by the members, including email, as we just discussed. It makes sense, as it's just language in that statute. And as I just said, as I indicated previously, electronic voting. You can provide an electronic ballot or electronic notice that sets forth the proposed action and how to use it. Give instruction on how to vote. For example, log in and use the SurveyMonkey type platform to vote and to count the votes. And if everybody remembers the hanging Chad guy, hopefully everybody remembers the 2000 election. I don't think there's anybody that young on this. So this change, and there's more of this on the next slide, I think is one that's going to be very useful for associations. So we're going to continue with this. Now, let me frame this. You may have members that have not opted in and designated an email address. If the association wishes to conduct a meeting via written ballot, you use the old method. You mail them the ballot and they mail it back, or they can email it back, or they can fax it back. Or members can also receive that ballot via email if they've opted in and email it back, or mail it back, or hand it back. Doesn't matter. So that's how I think the reins on written ballots have now been loosened quite a bit. All members shall be given the opportunity. Now, this is the other language in there, all in the statute. All members must be given the opportunity to vote by written ballot or electronic voting, or both. You may mix methods. This is what I was just saying. So if you have, again, for members who've not opted in, you still mail them a written ballot. That's fine. Members that have opted in, you can email them the notice. Members who have not opted in, who don't wish to use the SurveyMonkey platform, can return a written ballot and it will be counted. So you can see that the legislature has opened this up quite a bit, and I think everyone's benefit. It's the board's discretion, entirely the board's decision on whether to conduct its meeting via the written ballot process, electronic voting, or both. And remember 55A1-70, that's the opt-in provision. So the board has the power. And I will tell you, whatever it chooses, the time for which the ballot must be returned or the vote must be cast in order to be counted must be the same, whether it's a written ballot, electronic voting, email ballot, however you do it. The return by date must be identical. If it's not, I'm going to tell you that your vote's probably invalid. So to put that in perspective, your meeting notice, where maybe you mail out a written ballot, a return by date of November 1. That written ballot must be received via email, mail, hand delivery by November 1 in order to be counted. If you use an electronic voting method, perhaps SurveyMonkey, the vote must be cast by November 1. Anything cast after that, any ballots received after that are not counted. If the dates do not match, then your vote is probably going to be invalid. I don't know how much more clear I can be on that. So that's key. As I said, both return date for both must be identical. I'm going to open up. There's something in the chat. If the bylaw state annual meeting notice has to be mailed out via post office, these statutes override and electronic notification of the annual meeting will stand as long as members approve. I'm not sure what that means. We're going to get into this a little more as to how notices work, but in my opinion, this statute trumps the requirement of mailing if members opt in to receiving notices via email. That's the reason they're required to opt in. If your bylaws say notices must be mailed, I will tell you that the statute allows you to opt in by receiving an email. I don't think you have to mail it to those members who have opted in. If members have not opted in, you still need to mail it to those specific members.
So Chris, just for clarification, an amendment to the bylaws will not be required.
I do not think, as my opinion, no, the statute trumps, the statute controls. And the reason for that is there are only, the only reason to amend your bylaws is if there is something in your bylaws that, if there's something in the statute that says, unless your bylaws or articles of incorporation indicate otherwise. We don't have that in these statutes. The only place I saw that I've already highlighted, and that is where that is dealing with the limitation on virtual meetings. We don't have that in the notice requirement. There is no limitation in that language. It doesn't say except where the bylaws indicate otherwise. Thus, I interpret that to mean that the statute controls over any restriction in the bylaws. So virtual meetings are here to stay. Yes, I put my picture in where Alice would be in the Brady Bunch. I usually get some laughs with that. When we deal with these types of meetings, the board's got to make some decisions. The first decision is it going to hold a virtual versus live meeting? Virtual meeting, live meeting in person. I should have put in person. And how are they going to run them? For example, Robert's rules will apply. So how are we going to, as the chairman, as the president who was in charge of running this meeting, how are we going to deal with 75 people on a Zoom call, a Zoom meeting on the screen, and people are drawing back and forth and want to talk? And how are we going to do that? We're going to mute everybody? What about minutes? Do they need to be taken if the meeting is recorded? What happens to the recording if the meeting is recorded? Don, I've got 3 coming in on the chat, so I'm going to stop here and see what those are. Bear with me a second. Our emails. Okay, so the question has been asked. Our emails we already have on file considered opt-in. It should be, but I'm going to tell you, in order to dot your I's and cross your T's, it is my opinion that you should still solicit emails from the membership. The emails you have and already have, for example, email them and say, do you wish this to be your designated email for all future communications, and have them confirm it. I think it is, it's a conservative approach, but since this law change is there, and became effective last week, I think we should start at that as day 1 of these procedures. So my recommendation is, if you already have email addresses, you should still communicate with those owners and tell them and ask them to designate this as their email in the way they wish to communicate with the association and conduct business. I think that just covers you. The next question is, if there is a small meeting, can attendees vote by hand raising, yea or nay? If there's audio, so you can see everyone. I'm going to address that coming up. Okay. So other decisions the board need to make. Will it be in person? Will it be virtual? Will it be a written ballot or electronic voting with a gathering, as I discussed, excuse me, either virtual or in person? Keep in mind, you always had the ability to mail out your ballots and then hold an informational gathering while the vote is being conducted, after the vote is being conducted, before the vote is being conducted, to discuss the things. That's not changed. You still have that option. The question you will then be given is this. A board is considering holding an in-person meeting. But what if members don't want to come to the in-person meeting and they want to attend virtually? If you go back to the language I had on a few slides ago, the General Assembly repeatedly in 2 spots used the word solely in describing whether a meeting shall be held virtually or in person. I interpret solely to mean one or the other. You can't mix them. If the board chooses in person, it is my opinion, and I will tell you, it is the opinion of another major law firm that does what I do, Black's Law to Black. At least I got that from Harmony Taylor. So if any of you know her, you can confirm it with her. We discussed this at length. If it's in person, there can be no virtual attendance. It's one or the other. Now, what about this scenario? The board decides to go virtual. Is it okay for members of the association to get together at the clubhouse, for example, and all sit together in a room and conduct the meeting virtually? Is that possible, where some people are virtual and some people are in person? I submit it is. As long as they can participate with what's going on and communicate and vote, I submit that that's proper. So you could have 20 people in a room using one call-in. The key there, of course, is you have to make sure you identify that everybody there is a member. And if it's co-owners, only one gets to vote. How are you going to do that? It's going to be tough, but it can be done. On the other hand, if a meeting, and again, we're talking about conducting business, if a meeting is in person, then it's in person. If a member of the association says, I can't attend, I'm afraid to attend, I don't, for whatever reason, then they need to send in a proxy. They can attend virtually and they can watch it. You're certainly allowed to have an in-person meeting where a vote is being conducted and have members watch virtually, no problem there. But those members who are watching virtually at an in-person meeting cannot participate in the vote. I hope that's clear. That was that kept me, working all that out, kept me busy for about a day looking at this. Because logistics are one thing, but language in 7, and this is in 7-09, the language in the first 2 sections of that law tend to be a little confusing unless it is read as a whole. And reading the entire statute as a whole, it is my opinion that the board is required to choose one or the other. If the meetings are virtual, as I said, the members can meet up in a location and attend virtually if they comply, if the association complies with that statute there, 55A 709 A and B, and that is again being able to identify who everybody is and are they able to participate. There was a question that came in. I have a board that inquired on only the board of 3 gathered in person. I'm not sure I understand that question. Let me, Tommy, if you could maybe rephrase that for me and I'll get back to you. Okay, more procedures. Going back to what I just said. We've decided that we're going to hold our meeting virtually, our annual meeting virtually. We're going to conduct a vote virtually. How do we identify the attendees? There's no statutory guidance. Surprise, surprise, the General Assembly didn't tell us how to do that. So now we got to figure it out. And the question, Donna raised this question right before we got started here today. You got 2 members from the same household attend from different locations. What if that happens? Who votes? Who speaks for them? Because remember, it's one vote per lot or one vote per unit. A husband and wife, they don't get to vote twice. And what if they don't agree? What do we do about that? What do we do if a member can't log on? What do we do if members do not display their full name? Because after all, the association is required to determine who is on the meeting before business can be conducted at that virtual meeting. At a live meeting, you have sign-in sheet, you know who's there. So, and how do we deal with proxies? The proxies, I think, are pretty, I think that there has to be a procedure set on that, and I'll talk about that in a minute. When a meeting notice is provided, it's my opinion that that notice should require members to designate, if you have co-owners, you designate who's going to vote, either before the meeting or at the beginning of the meeting. I think that is appropriate. So if a husband and wife get on the call from different spots and you're going to take a hand raised vote, who gets to vote? They need to designate that at the beginning of the meeting or prior to the meeting, preferably. Obviously, that's going to require identification. Members who get on the Zoom call and have their first name or a nickname, you're not going to be able to verify who they are. The meeting notice that you send out indicating that this will be a virtual meeting, in my opinion, should contain a statement that upon logging in, the member's full name should be out on the screen. And if that's not possible, if, for example, we have a group setting like I discussed, where 20 people get together at the clubhouse and the camera's there, they're going to have to identify themselves at the beginning of the meeting. And you're going to have to go down the membership list to make sure they're members. It can be cumbersome, which is why you'll see at the end my recommendation on all of this. How do you vote? The question Donette raised. Do we raise our hands like this, wave to the screen? Or do you raise hands? I put exclamation point because there is, I believe, on all platforms, the ability to press a button and a hand gets raised, I think in the chat or by your name or something, and you go through a list and see your raised hands. Do you use that? What do you do about secret ballots? What if your bylaws require that a vote be taken secretly so that no one knows how anybody else voted? I'm not sure you have that ability to do it virtually at that point. If there's a mechanism that can be set up for privacy that way, then it can be done. But I know of no platform that would allow that. In other words, if I vote via hand raise, everybody else is going to see me. If I press a button and raises my hand on the little characters on the screen, everybody else is going to see it. Unless there is a way to, I guess, make that private, I'm not sure you can be able to hold your meeting virtually. You could, at that point, if you really wanted to hold meetings virtually, you could propose amendment to your bylaws to take out the secret ballot. That could be a possibility. But that is something that was not really designated by this statute, doesn't really address. More procedures. Understand, when you're conducting a virtual meeting, and let me just say this, virtual meeting is the same as in person. Robert's rules applies. The chairman's in charge. He recognizes people. He goes through the agenda. It's the same thing. The only difference is we're now using a virtual platform versus being in a room together. The board needs to adopt a policy on how, on muting people, when questions are going to be asked, and publish those either at the meeting notice or at least at the beginning of the meeting. I will tell you what I experienced, and I will be the first to say that I am not technologically savvy. I am learning quickly. I hosted my first Zoom meeting last week. I've always been a guest. I had the ability to mute everybody, and that was fantastic. I love that, because then I could sit there and listen to myself for 35 minutes and not be interrupted. That was awesome. However, that is not conducive. I was teaching at a board meeting, an member meeting, you're not there to teach, you're there to get business completed. So what policy you should adopt is really going to be up to your board, and your board knows your members. You know your members better than I do. But a policy on how virtual meetings are going to be run, I think the board can adopt that and publish that with the meeting notes. This, I will tell you, the change in this law is going to require your boards to work more. It's going to require more work from you if your boards choose this. Hopefully it'll be all on the front end one time and you're good for the future. But as we've seen, things change in the law, it can change rather quickly, and so we have to adapt. Quorum. Quorum can be more difficult to establish, just as I said, because we've got you could have multiple attendees from the same household and how to identify them. That's why I think it's imperative in your meeting notice, the requirement that if you're holding your meeting virtually, that members, when they log in, designate who's going to speak on behalf of that lot or unit and identify themselves with their full names on the call, on the meeting. Understand everything's still the same, so you must take minutes, and please keep this, make sure you understand, make sure your members and your boards understand this. A recorded meeting is not a substitute for meeting minutes. I'm of the opinion that a recorded meeting just lends itself to anguish, anger, questions, and problems. If you don't record your meeting, you're not breaking the law. If you are recording it, how long are you going to keep the recording? Who are you going to allow to see it? It's my opinion you shouldn't record it. There are members that are going to want them recorded. There are boards that are going to want them recorded. That's fine. It's up to in the end, it's a business decision made by the board, made by and working with the manager. But keep in mind that that recording is not a substitute for minutes, and minutes record what was taken, what action was taken, not what was said. The recording, unfortunately, records everything, what was said, and in a Zoom meeting, it records facial expressions, it records obscene gestures, it records rolling of eyes. So that recording could be dangerous if it gets in the wrong hands. So, in my opinion, if the board is going to record it, that recording should not be made available to the members, and it should be restored. And the purpose of recording it likely is to just make sure that we are keeping our minutes accurately. That should be all it's for. If you use the written ballot process or electronic ballot, as I indicated, you can hold a gathering to discuss the items on it. You must provide instructions on it on how to vote. I think we've covered that pretty clearly earlier. And it takes the place of an actual meeting, whether in person or virtual. You cannot combine them. I've had this happen before the law changed. If you choose to use the written ballot or electronic voting process, then that is how you're going to conduct your business, period. The meeting, the quote unquote meeting, occurs via the written ballot or electronic voting. Your gathering does not vote. You do not allow people to vote in person if you choose or virtually if you choose the written ballot or electronic voting process. Likewise, notices. You got to mail your notices out unless people opt in to receive the electronic notices. It's an opt-in procedure. Now, I'm going to give you the law according to Chris Gelwicks. Stick with what works. Last year, I saw so much more participation across the board. There were obviously some exceptions, but I saw so much more participation when we held the virtual gathering, because we couldn't get together because of COVID, and use of the written ballot. We've now, this legislature has made the electronic voting and the written ballot process even easier. I highly recommend using that process. If you're not conducting an in-person meeting, then vote via written ballot or electronic voting and hold an informational virtual gathering. That is my recommendation. Why is that my recommendation? Because it worked last year, and you don't have to go around and figure out how we're going to identify people on the screen. We don't have to identify who's going to vote out of what unit, what lot. The board meet, by the way, and then this is the only thing I'm going to say about your board meetings. Last year, that was about 18 months ago now when COVID hit, everybody thought, how are we going to conduct our board meetings? You always could use virtual platforms to conduct your board meetings. The only requirement was that board members be able to hear and participate. You could have done them you can do them via phone call. So your board meeting can and always could be virtual. That has not changed. So keep that, boards, and nowadays, I mean, I'm on my board for 3 more months, thank God. But, and I'm not, and I'm getting off. But we used to meet monthly. And because of this, now everybody decided, hey, we're going to meet virtually. Now we're having 2 or 3 meetings a month, and it's a real pain in the rear. But, it's easier. It's easier to get things done. So member meetings, virtual meetings require a lot of planning. And how much work do you and your boards want to do? Because a virtual meeting where you're going to conduct business is going to require more legwork at the front. Now, there are going to be boards that want it, and that's fine. Understand, you're going to have to adopt these procedures on identification of who's on there, and how you're going to run your meeting. You're going to have to adopt that in advance. And the board will have to adopt the policy, publish it to the members so they know what's going on. It seems to me that the electronic or written ballot is the easier way to go. And if you really want to do a virtual gathering, you can, and you can discuss all the issues that are pending and then send your ballots out after. Certainly possible, certainly viable.